Okay, it looks like we are being recorded, so here we go. My name is Tiffany Lashmet, and I'm an extension specialist in ag law with Texas A&M. My office is actually based about as far away from Pete as you can get. I'm up in Amarillo at our district office here, and I basically handle ag law issues. So I kind of focus on issues affecting Texas landowners. And one of those major issues is what we're going to cover today, the title here is Ranching in Oil and Gas Country. What are some of the rangeland challenges that we see? I'll start off my presentation with a quick disclaimer, and that is that I am a lawyer, but I am not your lawyer, so nobody needs to be suing me for malpractice. Basically, the way this works is I can give some general information. I can explain to you how the law works, some different principles, but I can't give anybody any specific legal advice. And that makes sense because I don't know the facts of your situation. So if you need that advice, I recommend you talk to an attorney that works in this area. If anybody has a hard time finding an attorney who works in ag law or in oil and gas or anything like that, feel free to get in touch with me, and I'll give you all my contact information at the end. I'm more than happy to get you in touch with some folks who I know that frequently represent landowners in lots of different kind of ag transactions. All right, so here's a little roadmap of what we're going to cover today. Basically, I've kind of broken things down into two sections. So first we're going to talk about surface owner issues, then we're going to talk about mineral owner issues, and then I'm going to give you a little, for more information, I've actually co-authored a book on oil and gas in Texas. So this is kind of what we're going to cover. Like I say, the first half will be kind of focused on surface owner issues, the second half on mineral owner issues. So we'll kick things off with surface owner issues, and let's talk first, this is real basic. This is probably, kind of a review for most of you guys, but just in case, I like to start from the beginning. Let's talk about the fact that we can have severed estates in Texas. And so what that means is that a single piece of property can be severed into multiple different estates. The most common severance we see is where the mineral estate is severed from the surface. Estimates show that about 2/3 of Texas land probably has severed mineral interest. So the way that looks is, if you buy a piece of property, then you own the surface of the land, but somebody else might own the mineral rights to that same land. And so we can end up having different owners or multiple owners of different estates on the same property. And so while certainly severed mineral estates is the most common, there are other estates that can be and that we see severed as well. One of those is groundwater rights. We're starting to see this pop up more and more in Texas where if somebody's willing to sell property, they might be wanting to reserve the groundwater rights to that property. We also see this sometimes here in West Texas where folks want to reserve wind rights to the property. So they're willing to sell the surface, but they want to keep the wind rights and the right to enter into a lease agreement for a wind farm on the land. So we start off, like I say, with the idea that estates can be severed. So this is a question I get a lot. How do I know if I own any minerals? How do I find out if my property has a severed mineral interest that might be owned by somebody else? Unfortunately, it's not as easy to figure out as we might think. The basic rule where we start on this is that if a deed does not expressly reserve the minerals, then ownership passes. So if somewhere in the deed, it's going to have to show that a current owner reserved or sold the mineral interests separate from the surface. And so, if you bought land last year and you say, well, in my deed it didn't say anything about the minerals, so they must have passed. That's true in that the prior owner, the guy right before you, passed any mineral interest that he had. But things get tricky because what if that prior owner didn't own any minerals? What if they were reserved 8 deeds ago? In that situation, he might have passed anything he owned to you, But if he didn't own anything, that means he passed nothing. So I know that that can be a little bit confusing. Basically, what has to be done in order to figure out if minerals were severed is you kind of have to go back through the deed records. Those are at the courthouse. You got to go in, pull the records for your property, and then try to sort of construct a title, a chain of title back to see if those minerals have been reserved. A few options for how to do that. One thing that can be done, if you've got an oil and gas company who's there wanting to lease your land, they've probably already done this type of title chain because that's how they figured out to come talk to you or whoever else they need to be speaking with. So one thing you can do is if there is an oil and gas company involved, you can certainly ask them to see the chain of title that they've put together. I mean, they've got lawyers on retainer who do this kind of thing, and they may be willing to let you take a look at that. Another option you can try is to check your title insurance policy. When you purchase the property, it may or may not address mineral ownership. A lot of title insurance policies now won't address this. They won't insure for mineral ownership because it is such a complicated issue, but it's something you might look at just to see. Like I said, you could go yourself and do a title search at the courthouse. I did these for a little while in my former life when I was in private practice. They are miserable to do, especially if there have been a lot of severances or a lot of sales or inheritance of the property. It's pretty tough to track those titles. In light of that, you've got a couple of options. You can hire someone to handle a title search for you. Obviously, the downside to that is you're having to pay somebody to do it. You might look and see if you can find a landman. That's somebody who is trained to do these title searches. Generally, landmen work for oil and gas companies. But given the kind of slow go right now with oil and gas production, there are some landmen around who might be looking for a little work on the side. And so you may be able to find one of those fellas and see if they could go down and do the work for you. Another option is to hire an attorney. There are plenty of attorneys in Texas who do kind of oil and gas title opinions. You may be able to get one of them hired to kind of look into it for you. So I wish it was an easier answer, and when you bought and sold property, there was a box that got checked that explained mineral ownership, but there's just not, unfortunately. So let's talk about the surface estate versus the mineral estate. So now we know that you can have property that's severed into separate estates. And like we said, there might be one person who owns the surface, somebody else who owns the minerals. I think it's very important to understand which substances go with which estate. And some of them are easy. So for example, probably everybody here understands that the ownership of the oil and gas or the oil and gas rights belong to the mineral estate owner. And so that one's pretty straightforward. Most people are pretty comfortable with the idea that the gravel, for example, belongs to the surface owner. But let's take a look at some other substances that you might not be aware of. So under Texas law, there are 5 substances that always, as a matter of law, go with the mineral estate unless they have been expressly reserved out. And those are oil, gas, salt, sulfur, and uranium. So those substances are always part of the mineral estate unless they've expressly been separated by an agreement. All right, you'll see here on both the mineral and surface list I have listed coal, lignite, and iron ore with a little asterisk. The way courts have treated those is it depends on the depth. If they are deeper than 200 feet, they're considered part of the mineral estate. If they're shallower, they're considered part of the surface estate. All right, so what substances do we know are part of the surface estate? Texas courts have held that the following are, that's gravel, caliche, sand, surface shale, limestone, groundwater, and that shallow, less than 200 feet, coal, lignite, and iron ore. All right, so when we say, okay, I own the surface, that means I own the rights to those surface substances that you see listed there. Again, as always, an agreement between the parties could change this. So, for example, like we talked about earlier, sometimes we see severances of groundwater. So it could be in the deed to the property, one person owns the minerals, someone else owns the surface, and then a third person severs out the groundwater rights. If that happens, obviously the groundwater is no longer part of that surface estate. All right. Okay, so now we kind of know that we can sever estates. We know which substances belong to which estate. The next question we need to look at is which estate is dominant. This is one of the most important issues for Texas landowners to be aware of. And to be very frank with you, this is the issue that I probably get the most calls on, is rights that go with a dominant estate. So between the two estates, the mineral estate and the surface, Texas law is very clear that the mineral estate is considered the dominant estate. The surface estate is what is called the servient estate. And the reason for that is it would be impossible for a mineral owner to produce the minerals if he or she could not use the servient surface estate. We can't just magically get the oil from the ground. You have to use the surface to get to it. And so in light of that, Texas law looks at the mineral estate as being dominant. What does that mean? Here it is. It means that the mineral owner or the oil and gas company that the owner leased the minerals to can use as much of the surface estate as is reasonably necessary to produce the minerals, free of charge and without permission to the surface owner. All right, so let's think about that again. If someone has leased the minerals beneath the property, they have the automatic right to use as much of the surface as is reasonably necessary to produce the oil and gas, even if the surface owner might object, and even if the surface owner gets no payments. So another thing to know about this is if they do use the surface, there's not any sort of automatic or implied obligation for them to restore or repair that surface. So let's say that an oil and gas company leases the minerals beneath your land. You own the surface. They come in and they want to put a 5-acre drill site, and they want to build roads and put in gathering lines, and they do all this. When they leave, they don't have to reseed grass. They don't have to get the property back to where it was before, absent a requirement that they do so in a contract. And we'll talk about that in a minute. So here are some of the key examples we see. This dominant estate rule may give them the right to drill in the middle of a field or a pasture or even a center pivot circle. They've got the right to build roads. They can build drilling pads. They can put in compressor stations. They can put in gathering lines kind of on that unit to gather the oil and gas. They can drill disposal wells. Those are those saltwater wells where they'll put the water produced with the oil and gas production down, a mile or so beneath the surface. So this dominant estate rule is very important and has major impacts on Texas landowners. All right, now there are a few limits on the dominant estate rule that are important to be aware of. Frankly, these aren't as strong as we would probably like them to be, but at least there's something. The first one, like we said, is that the mineral owner can use the amount of the surface that's reasonably necessary to produce the oil and gas. They can't overuse the surface. So, for example, they can come in and, they can use as much surface as they need to put in a drilling pad. What they can't do is come in and clear out 20 acres of your property and park all of their equipment that they're going to use on every site in the county on your land. That would be overuse of the surface. Okay, another thing that they can't do is they can't come in and use your surface to benefit production on another lease. All right, so for example, we said earlier that groundwater is part of the surface estate, which means that unless the parties agree otherwise, the oil and gas company has the right to use as much of your groundwater as is reasonably necessary to produce oil and gas. What they can't do is take your groundwater and go, 100 miles down the road onto another lease that's not pooled with yours and frack a well with that water. So they have to use it to benefit production on your own property or a property that's pooled with yours. All right, so we have this reasonably necessary sort of protection. Another protection that exists is called the Accommodation Doctrine. This is a common law rule. That means it's judge created. It came from court rulings. And basically what this rule says is an oil and gas company has to accommodate existing surface uses if a landowner can prove 3 requirements. Okay, the first is that oil and gas production would substantially impair the existing surface use. Second, there has to be no reasonable alternative method for the surface owner to continue making the surface use. And third, the oil and gas has to be able to be produced in another way that would allow the surface use to continue. I'm going to give you a couple of examples that are going to help hopefully explain that because it's kind of just a jumble of words until you hear how it works. So the first case, the lead case on this accommodation doctrine is Getty Oil Company versus Jones. And this was decided by the Texas Supreme Court back in 1947. And in this case, Getty Oil came in and they leased the minerals under some property owned by the Jones brothers. The property was up here in the Panhandle, and the brothers raised corn, and they had a center pivot circle on the property. And so the oil company came in. The brothers, they were just surface owners. They did not own the minerals, so they didn't really have any say. They weren't involved in the negotiations. The oil company comes in, and they want to put their rig right in the middle of the center pivot circle. And the brothers said, hey, wait a minute, that's just not going to work. That's going to substantially impair our existing surface use. They're growing corn. They presented evidence that they had no reasonable alternative way to irrigate the corn. They had testimony that came in and basically said that the only way to irrigate corn in this area was to use a center pivot. There weren't other options. And they said the oil and gas company can produce the minerals another way. They said one option that they have is they can just use a smaller pump jack to, get the oil. Shorter, if it was shorter, I think it had to be under 9 feet or something in order to allow the sprinkler to go ahead and pass by. Or they could do what some other oil and gas companies had done in the area, and that was they could use a taller pump jack, but they could dig a hole and set it down in the hole to make it short enough where the pivot could still continue to go in a circle. In that situation, the court said, yes, this is what the accommodation doctrine is designed for. These are facts that, in this instance, the surface owner would be protected, and the oil and gas company could still produce their minerals, but they just have to do it using one of those alternative methods that would let the brothers keep irrigating their corn. So that was kind of the lead case, the first case on this issue in 1947. Unfortunately, no landowners have been successful since that time. A far more common sort of look at how courts handle these cases is an example called Merriman versus XTO. This case was also decided by the Texas Supreme Court. It was back, I think, in 2013 that this came out. In this case, you had a landowner who lived in central Texas, and he raised cattle. On his property, it was rangeland, and he had one set of permanent corrals. He did not own the minerals. So the oil and gas company enters into a lease with the mineral owners, and then they come and they tell the surface owner, okay, we're here to put in our drilling pad, and they want to put that right smack next to his permanent corrals on the property. And so the landowner says, hey, wait a minute, the accommodation doctrine protects me. You need to accommodate my existing surface use. So he walks through these 3 prongs of the test that he has to prove. First, he says that the oil and gas production would substantially impair his existing surface use. It'd be pretty tough to work cattle and load cattle out of the chute when there's a drilling pad backed right up next to it. Second, he argued that he had no reasonable alternative to make the surface use. And his argument there was, this is my only set of corrals, so that's the only place I can work my cattle. And then third, he said the oil and gas can be produced another way. All they have to do is move their drilling pad over away from my corrals, and they can still use horizontal drilling to get the production from under the property. Sounded like a pretty solid case. It gets to the Texas Supreme Court, and the Supreme Court a couple of years ago sided with the oil company. And what they said was Mr. Merriman proved the first prong and the third prong. There would be a substantial impairment of his existing surface use, and the oil and gas could be produced another way, but they said he failed to prove that he had no reasonable alternative as the surface owner. What they said was he could go and buy temporary panels, he could put up temporary corrals to work his cattle. Therefore, he had an alternative method. The Accommodation Doctrine did not apply to protect him, and the oil and gas company could drill their well right next to his corrals. So I tell those two stories to show that, yes, the Accommodation Doctrine exists. There are circumstances where it could protect a landowner, but understand it's not great because the Merriman facts looked pretty good, and the landowner still lost when he got to court. All right, kind of the third limit on this dominant estate rule is this doesn't somehow allow the oil and gas company to be negligent. So just because they are the dominant estate would not ever prevent a landowner from suing them for negligence. So for example, we've seen cases where the oil and gas company comes in, uses the surface, might have a spill, either a spill of oil, crude oil, or a spill of salt water or wastewater. If that happens, a negligence suit could still be brought. So that is always an option available to the landowner. So basically, what you've probably taken away from the last couple of slides here is the law on this is not great for landowners in Texas, for surface owners especially. And so because the law is not great, the best thing that you can do as a surface owner is to negotiate surface protections to try and protect your land and limit some of these automatic rights that the mineral owner or the mineral lessee has. So let's talk through just some examples of things that might be done. One term that you could negotiate is that they have no free use of groundwater or other surface substances. You think about 20 years ago, this groundwater thing wasn't that big of an issue because they didn't use that much water to drill a well. It was, maybe a couple 100,000 gallons. Now, because of fracking, there's an extensive amount of groundwater used to drill wells. Lots of wells are using, 3-4+ million gallons of water. You don't want them to be using that water for free. And so what some folks have said is there's no free use of groundwater or other surface substances. If they want to use their groundwater, they actually need to come and purchase that from the surface owner. You could put in limitations on the placement of drilling pads in certain areas. So, for example, in the Jones versus Getty Oil case, the brothers could have had an agreement whereby the oil and gas company was not allowed to put their drilling equipment in the center pivot circle. So that'd be another example. One thing you can do is you can require upfront compensation for surface uses. So, for example, if you're negotiating an oil and gas lease, you could negotiate payments for surface damages. Sometimes we see payments, X amount per drilling pad, or, roads will be X amount per rod or per foot. So you can negotiate those up front as well. Another common provision that we see is a prohibition on drilling disposal wells on the property. You may not want that oil and gas wastewater disposed of beneath your land. And so these are some examples of terms that can be negotiated. In the book that I mentioned that I'll give you the information for here at the end, there's a whole chapter on protecting yourself as a surface owner with tons of suggestions of terms that can be included. I've given you 4. There's probably 100 things to think about, but maybe this will give you at least some idea of what those terms might look like. How do we do this? Where do we negotiate these terms? The best place to do it is in the oil and gas lease. Because in that situation, You've got something that the oil and gas company wants, right? You've got the minerals. They're wanting to lease them from you. You've got some negotiating power. This works out fine if you maybe are a mineral owner or own some fraction of the minerals, because in that case, you've got a seat at the table when they start negotiating that oil and gas lease. And so if you own any part of the minerals, this is where you want to make sure you negotiate these protections. Before you sign that lease, you need to get them in there. If you don't own the minerals, you may be able to figure out who does and ask if you can have a seat at that table. Ask if there are, provisions that they'll include in their oil and gas lease. It frankly may be worth it to you to offer to even compensate them if they will get you certain terms in that oil and gas lease. Because like I say, that's the best place to negotiate them. You're in the best position to do so. What if the lease has already been signed? I get this question a lot. Maybe the lease was signed by your great-grandpa in the 40s. It's still going on. There is nothing to protect you in there. That ship has sailed. The other place we see this come up is if I'm a surface owner, I didn't even know somebody owned the minerals, and the oil and gas company shows up at my door with a signed lease, and they're ready to go. Well, in that situation, obviously, you can't get the terms included in that oil and gas lease, but what you can do is you can try to seek a surface use agreement. What that is, it's just a contract between the surface owner and the oil and gas company that sort of governs the relations between the two. The kicker here is that in Texas, there's no legal requirement that they have to give you this type of agreement. Several other states have that requirement. So, for example, Oklahoma, New Mexico, North Dakota, in those states there is actually a statute that requires a surface use agreement and some surface payments to the surface owner before a mineral operator can come in and start working. Texas doesn't have that. So there are going to be some companies that will not work with you on a surface use agreement. However, there are a lot of companies that are willing to negotiate. You probably won't get everything you want. You're sure not going to get all 100 of those terms that I mentioned in our book. But you may be able to get a few protections negotiated because, they want to have a good relationship with you. They want to, not have issues every time they come out to do something on their lease. So that's probably your best option. Another, little piece of advice, if there is ever a situation where that oil and gas company needs something from you, sometimes they will need an easement to go across your property to get to another lease. Or they're going to need to put in not a gathering line, but a pipeline to transport the oil and gas. They might seek an easement. Anytime they ask you for something, that's a great time for you to ask them for one of these surface use agreements in return. So that's just something to keep in mind on that front. All right, so that kind of covers our surface owner issues section. I know this was fast and furious, guys. When I usually do these presentations, the most recent one I did lasted about 3.5 hours, and we still ran out of time. So trying to cover all this in an hour is pretty fast and furious. If you guys have any questions so far on the surface owner issues, feel free to type them in the chat box there on the left of the screen. We'll answer those either at the end or kind of as we go along, and I'm happy to take any questions that you guys have. All right, so with that, let's turn to mineral owner issues. All right, so we've kind of focused on the surface owner, what the surface owner concerns are. Let's look now at what some of the concerns and some of the things that mineral owners need to think about. So first thing, what are mineral rights? Everybody always says, I own the mineral rights, or so-and-so owns the mineral rights. What rights exactly do you own? Under the law, there's 5 things that go along with owning mineral rights. I think in every law school in America, they describe these sort of as the bundle of sticks. There's kind of 5 sticks that go along with mineral rights. Real quick, Lynn, I'm going to answer the question you just typed. She said, can solar rights be reserved as a surface owner right? So basically, yes, but. So here's how it works. In general, solar is, I think all lawyers would agree in Texas, is considered part of the surface estate. So if the surface owner wanted to lease out the solar rights, it's the surface owner, not the mineral owner, who has the right to do that. Now, if you're a surface owner and you're going to sell property, you could try and reserve the solar rights. You're probably going to have a pretty tough time getting that property sold. And here's the reason. If you've ever seen a solar project or one of these solar farms like they're called, generally those panels that they put up pretty much take the entire property and you really can't do much around them. So, unlike a wind project or unlike an oil or gas well where you can still farm around them or graze cattle or sheep around them, with solar projects that's oftentimes a lot more difficult to do. And so it may be tougher from a sales standpoint to convince somebody to buy property if the solar rights have been reserved. But if you can find somebody to agree to that, absolutely, you could reserve the solar rights on that land. Okay? All right, so back to what are the mineral rights? Like I said, we have these 5 rights that are part of the bundle of sticks. Let's walk through these. The first right is a mineral owner has the right to explore and produce the mineral estate. What this is, that's just the right to actually drill. So if you own the minerals under your property, you have the right to go in and drill for those minerals. Normally, most folks don't have the knowledge, the time, the expertise, the money to do that. And so this is the right that gets leased to the oil and gas company. This right to explore and produce the minerals, this is usually what is leased and then held by the oil and gas company. All right, the next right in the bundle of sticks is the executive right. And what that means is the right to negotiate and execute a mineral lease. And so if you own the mineral rights, that means you've got the right to go out and negotiate with a company and sign a lease agreement. All right. So our third right in the bundle of sticks is the right to receive a bonus payment. You can think of this kind of like as a signing bonus in baseball. It's a payment that's made up front for you signing the lease agreement. In general, these are made per acre. And they can range, they could range anywhere from, $5 an acre to $5,000 an acre, just depending on where you are, what the oil and gas market's like, how hot the play is, things like that. This is something that you negotiate in that oil and gas lease, the amount of the bonus. All right, next up, you've got the right to receive royalty payments. What that is, that's just a fractional share in the production. Kind of more common nowadays, we see, a fifth or a sixth. Sometimes we see something like, 3/16. 1/8 kind of was common back, like in the 40s and 50s. A 1/8 royalty now is not great for a landowner, so I'd kind of be a little bit wary if that's the number. But you have that right as well. Then the fifth right is the right to receive delay rentals. What delay rentals are, they're sort of payments made to the landowner if drilling doesn't commence right away. The kicker with delay rentals, you really don't see these very often anymore because most companies now are going to offer you what's called a paid up lease. You'll see in the title of the lease, it says paid up lease. If it says that, that means that they're not going to be paying delay rentals. So kind of keep an eye out on that. All right, so if you own the mineral rights, you own these 5 bundles of sticks. If that were the end of the story, this would be far less complicated. Unfortunately, it's not. And these rights can be divvied up in several different ways. One thing that could happen is you could divvy them up by right. And so sometimes you'll see something like this. All right, I'm an attorney. I have one brother who ranches. My parents, if they own minerals, might say, hey, it makes the most sense to give all the executive rights to Tiffany because she's the one who knows how to negotiate a lease. So let's give her all of the executive rights, but let's give my brother the right to get the bonus payment, which is the per acre payment, to kind of help keep the farm going. So in that situation, it might be that I hold the executive rights, he holds the right to the bonus payment, and then we just share, in percentage to our ownership, the other rights. So you can divvy them up by type of right. The other thing you can do is divvy them up by percentage. And so what we see oftentimes, if there's me and my brother, my parents have 2 kids, they will give the mineral rights, and they'll say, they each of us will get half the mineral rights. So we would own an undivided half interest in those rights, and that would mean we each have the right, we each hold half of each of these rights. All right. So if that happens, let's talk about real briefly about being mineral co-tenants. This is the situation we just described where there are two siblings. Our parents say, okay, we're going to leave these mineral rights, an undivided half interest to each of the children. So absent one party being given the executive rights, right? So as long as one of us wasn't told, okay, you get 100% of the executive rights, any co-tenant has the right to lease out his or her portion of the mineral rights, right? So what that means is that if I have, half and my brother has half, if he wants to lease to an oil and gas company but I don't, he's got the right to do that with his portion of the property. At that point, I can either ratify his lease, kind of means join in. I could go out and sign my own lease for the other half, or I could just refuse to lease my half. All right. Importantly here, if I refuse to lease my half, that does not keep his folks from producing oil and gas with his half. The way that works is they can come in and produce, but they are going to have to pay me a percentage share of the profits. So if I own half of the mineral interest, they're going to owe me half of the profits. All right. So let me just give you a quick example. We have A and B. Adam and Beth are mineral co-tenants. A owns 90% and Beth owns 10%. All right. If Adam wants to lease his 90% to an oil and gas company, that company might take that lease. All right. They would lease the 90%. They could produce the oil and gas, and then they owe Beth 10% of the profits because she has a 10% interest. Okay. Now, the reverse could be true as well. Beth could go out and lease her 10% if she wanted to. Probably no oil and gas company would ever do that, but she could go lease her 10%. They could produce, and then Adam would get paid 90% of the profits. Right? So that's sort of how that works with mineral co-tenants. That can get pretty complicated, but that's at least kind of a brief overview. Right? A few things to look at if you are looking at an oil and gas lease, or you're trying to negotiate one or figure out what the heck's going on with one. The first thing is the term of the lease. How long do oil and gas leases last? The lease is going to probably contain what we call a habendum clause. It's going to look something like this. The lease shall remain in force for a term of 3 years, and so long thereafter as, and then it'll have some term, something like production and paying quantities continues on said land, or operations as herein defined continues on said land. This is very common for how lease terms are put forth. And so we can break this kind of into two pieces. The first here is what we call the primary term, and that's that 3-year part we see at the beginning. So no matter what, the lease is enforced for 3 years. Okay, that's the primary term. Whether they drill or don't drill or whatever, the lease lasts at least that long. Okay, so that's called the primary term. Then we get the secondary term, and that's what comes next. So the lease lasts, we know, for 3 years, but then it will last as long thereafter as production and paying quantities continues on the land. And almost always that secondary term is open-ended. All right, so we don't know. This lease could last 3 years. It could last 300 years. We just don't know how that well is going to produce. All right. One thing when you're negotiating these, make sure whatever the measure is for that secondary term, whether it's production and paying quantities or operations, make sure that's specifically defined in the lease so that everybody knows exactly what has to occur for that lease to continue. All right. Another thing to be aware of, watch out, leases sometimes include options to extend. So what you might see, is a lease that's going to last for 3 years with an option for that primary term to extend 3 more years if the oil and gas company elects to do that, and then for so long after as production and paying quantities continues. Those options generally favor the oil and gas company. And that makes sense, right? Because if they're the one who gets to decide whether to exercise that option or not, they're going to do it in their favor. So, for example, if lease prices have gone way down and they're paying too much for your lease, then they're probably not going to exercise their option. On the other hand, if prices have gone way up and they got a great deal, then they probably will extend that option or use that option to extend to keep you in that lease. So kind of be aware of those, be a little bit leery of those options to extend. All right? The other thing to be aware of, and there are many examples of these, we've included several of them in that book I mentioned earlier, you have to watch out for savings clauses that are contained in an oil and gas lease. And every lease, almost, I feel confident every lease, will have these. So what you might see is that what we see above, right? The lease is going to last for 3 years and as long thereafter as there's production in paying quantities. So what that means is as soon as production ceases, then the oil and gas lease ends, right? And you're free to lease your property again. But you got to watch out for things that are what we call savings clauses. So for example, sometimes you'll see a shut-in royalty clause. What that clause says is they're allowed to shut in a well and just not produce from it if they pay you a fee, and that will let the lease continue. So even though as soon as they shut that well in, there's no longer production in paying quantities and the lease should end under that habendum clause, the shut-in royalty clause lets them keep going. It's sort of like a fiction, like the lease continues even though there's not production in paying quantities if they pay you a fee. There's similar clauses called a cessation clause, a dry hold clause. Just watch out for those. Make sure you understand when they can occur, and you want to limit the time on these kind of to as short as you can get it. So, for example, if they give you a lease and they want a cessation clause that lets them hold the lease even if there's no production for 180 days, it's in your interest to try to negotiate that 180 days to a shorter amount of time. All right. Next up, this is kind of a complex thing, but it's pretty important, so I at least want to mention it. There's a lot more information on this in the book that I mentioned that I'll talk to you about in just a minute. So basically, if you sign a lease agreement, production on any portion of that property is going to hold the entire lease. Right? So we just talked about once that 3-year primary term is up, then the production in paying quantities holds the lease. So let's say that you leased out 1,000 acres. Actually, I may have an example here. Let's see. Yeah. So if you have 1,000 acres that you lease to an oil and gas company, all right, during the primary term, they lease one small well that's got a 40-acre production unit. All right? So they've got one well, 40 acres on your 1,000. That means you're really only getting production from those 40 acres. The rest of the 960 acres, you're not getting a royalty payment for. There's no production, but it holds the lease because production in paying quantities anywhere holds that entire lease. Right? So that's something important to be aware of, and we want to try to limit that because in a perfect world, what you would like to do is let them go ahead and hold the 40 acres that they're producing from, but then you want the 960 acres back so that you could release it and try to get production on that. All right? So next up, we have another example. This deals with the vertical severance. Here again, if you lease 1,000 acres and they drill one shallow well that's about 200 foot deep, that well's going to hold all other depths, even though you're not getting production or payments from anything deeper. We saw this a lot in the Eagle Ford Shale. What happened there is there were some leases where folks signed them back in the 30s and 40s, and for 80 years, those wells were held by these shallow wells. Well, then we figured out some technology that let us get into the shale play. Folks were not getting new leases, new bonus payments because those shallow wells had held the deeper depths all those years. So what you can do in these instances to prevent that is you can include severance clauses in your lease. So an example of a horizontal severance is you could say something like, at the end of the primary term, the continuation of the lease is going to be limited either to the formation or depth of the deepest producing unit. Any deeper regions are released from the lease, and that means that you can lease them again. Okay, vertical at the end of the primary term, only those held in production units shall continue to be held by the lease. All right, so just think about those, something to consider when you're negotiating. Okay, real quickly, we're going to mention royalty payment clauses because I want to make sure and leave some time to answer questions at the end here. The general rule when you're dealing with royalty payments, you got to pay attention to your lease language. To kind of see how you're going to be paid. There's lots of different ways they can do it. They can pay you on proceeds. They can pay you on net proceeds, gross proceeds, market value at the well. I mean, there's 100 different ways to do it. So pay attention to that. But understand on costs. This is a huge issue that's litigated all the time across the country, frankly. The basic rule is that a royalty owner does not pay production costs in Texas, but they share in their proportion of post-production costs. So what that means, at least in Texas, is it's the cost of getting the oil from the ground to the wellhead. That's all on the operator. The royalty owner doesn't share in that. But once that oil gets to the wellhead, we have what are called post-production costs. Those are costs to get it from the wellhead, maybe to a treatment facility or to the interstate pipeline. Things like, treatment costs to remove, excess water or excess CO2, compression costs, things like that. Those costs the royalty owner shares in unless there's an express agreement to the contrary. So if you have an oil and gas lease, you can modify this rule by including clear language that shows an intent to modify. Here's where things get tricky. I'm going to give you 2 examples. Okay, the first example, it was from a lease in a case that just recently was decided in Texas. It said that the royalty owner would get 25% of the market value at the well for all gas produced from the leased premises, provided, however, there shall be no deductions from the value of the royalty by reason of any required processing, cost of dehydration, compression, transportation, or other matter to market such gas. Okay, another example in that same case, it said that there was a perpetual cost-free, except only its proportion of production taxes, overriding royalty of 5% on the gross production obtained. The court said that the second clause there was sufficient to show an intent to modify, and so under that clause, costs could not be charged. However, they said that the first clause, which frankly I thought was better, did not show a sufficient intent to modify, and so under that one, costs could be charged to the royalty owner. This is my takeaway point. Royalty payment clauses and cost prohibitions is a tricky, confusing mess. You want to talk to an oil and gas lawyer and make sure they're involved when you're negotiating lease agreements with that issue. Okay. The last thing, this is what I've been plugging kind of the whole time as we go. We just, earlier this year, wrote a handbook. It's called Petroleum Production on Agricultural Lands in Texas, Managing Risks and Opportunities. I think it's about 150 pages long. It goes into a lot of depth and a lot of detail on many of these issues. In there, the first chapter kind of covers issues that you would see. It sort of walks you through what oil and gas production looks like on your land. There's pictures. It describes what's done. It talks you through fracking, what exactly happens. So it's kind of like oil and gas production 101. All right. Then we've got a chapter on surface use issues, and that just talks through, how the law works on all that, terms you should consider. There's a couple of checklists included in there that might be helpful. Then we turn and we look at mineral owner issues, and we actually walk you through kind of a typical oil and gas lease. We talk about what these clauses mean, what clauses we would recommend, or not recommend, but should be considered to be added, what things might need to be taken out, kind of walks through that. And then the final chapter actually looks at negotiating pipeline easements and offers some suggestions and kind of a checklist on that as well. There's a link here where you can go and get a copy of that book. You can just download it from there. It's free. Also, I'm going to give you my email address here in just a second. If you want to shoot me an email, I'm more than happy to email you a PDF copy of it as well. Okay, last thing before we turn to questions is I have a blog. If y'all are interested in ag law, we talk a lot about oil and gas, as you might suspect. The address for that blog is agrilife.org/Texas Ag Law. I post a couple times a week. Like I say, if there's cases that come out, if there's news, anytime I write a handbook or a checklist, it gets put on the blog. So feel free to visit that website. If you're interested, you can put your email address in this box where the red arrow is. Follow the instructions to subscribe, and my blog post will come to you just like an email from me. Right? So lastly, I want to make sure y'all have my contact info. Here's my email address and my phone number. That blog address is there at the bottom. If there's any information I can get you or questions I can answer, I am more than happy to do that. Meanwhile, I'm happy to take questions today. Feel free to type those in the chat box. It looks like we have a couple. Forrest asks, if rights to solar or wind are reserved, does that estate have a dominant status to access the surface to exploit them? Great question, Forrest. The answer on that is no, at least not yet. Solar and wind have never been held by a Texas court to be considered dominant. And so what that means is if somebody, has solar rights, then they are going to negotiate exactly what can be done. So if you see an oil and gas lease, a lot of times they're about, 4 pages long, 3 pages long, pretty short. And the reason for that is we have those dominant estate rules in there that are kind of automatically implied. You don't really have to include them in the lease. If you look at a wind or a solar lease, they're going to be super long, like 40 or 50 pages, and all the rights to use the surface are included in that agreement. The reason I said not yet is the Texas Supreme Court in the last couple of months sort of threw some folks, myself included, for a little bit of a loop whenever they considered a groundwater case and for the first time ever held that a groundwater estate is considered dominant to the surface like oil and gas. And so now under Texas law, if someone owns the groundwater estate, they have that automatic right to use as much of the surface as is reasonably necessary to produce the groundwater. And so that was kind of new. I didn't really see that coming, so I want to at least hedge my bets on the solar and wind in case something crazy happens in the future. For now, there's no dominant right. Okay. Terry says, SWD have generally been considered a surface right from my experience. Has something changed or can you explain? Does SWD mean solar and wind development? Terry, I'm assuming that's what you meant. Saltwater. Okay, so in general, as far as water goes, in general, groundwater has been considered a surface right. Yep, groundwater is owned by the surface owner. Like I said, unless that's been somehow severed off. If there's not been some sort of agreement otherwise, then groundwater belongs to the surface owner. Where things can get a little bit tricky in the oil and gas is remember that because groundwater is part of the surface, unless it's agreed otherwise, then that water can be used by the oil and gas company for production to the extent reasonably necessary. As far as saltwater disposal wells go, because courts in Texas have said that is something reasonably necessary to produce oil and gas, court cases have said those can be drilled as part of that reasonably necessary use, even without surface owner permission. Now that, of course, that is if there's oil and gas production going on the property, and they can dispose only of water that is produced from that property. If they wanted to come in and drill sort of like an off-site disposal well, obviously then in that situation they don't have any implied right to do that. Okay, any other questions? If you have them, just type them there in that chat box on the left, and I'll be happy to take a stab at them.
Heidi, I have a question. Kind of fortunate that I can talk and I have to type. I was reading the article on National Geographic about the Ogallala Aquifer, and in your talk today, the question that came to my mind is, a bunch of these counties have underground water districts. So who would have dominance over how that underground water district or underwater would be sold? The water district first, then the landowner?
Great question, Pete. Great question that has a more complex answer than we can even imagine. I actually wrote about a 50-page long paper on that issue. So
Oh, wow.
in Texas, it's really interesting. There's a law that talks about exempt wells, and so there are certain wells, even if you're in an underground water district, if you want to drill certain wells, you don't have to get a permit. You just kind of have the automatic right to drill those. A domestic well is one example. A livestock well is another. Then there's a provision in the water code that says that wells water to be used for drilling and exploration of minerals, or no, it's exploration and discovery of minerals, something like that. Those are exempt, and you don't have to get a permit from the water district. So then the question becomes, is fracking considered drilling and exploration, or is it considered production? If it's considered drilling and exploration, then the groundwater districts really don't have any say over how much groundwater is pumped to be used for the drilling and exploration as it would be considered. On the other hand, if it's considered production, if fracking is production, then they would have to go through the permitting process, and the district would have authority. So where we run into problems, as you know, is we've got about 100 different groundwater conservation districts in Texas. They don't treat this the same. And so about a third of the districts take the position that these wells are not exempt, and that if you want to use water, you actually have to go get a permit from the district. About 2/3 take the opposite position, and they say that they are exempt and they have no recourse to deal with how much can be pumped. So it's an open issue in Texas. We've seen the legislature try to deal with it a couple times, but nothing's been passed yet.
Thank you. I guess I will sit here and I'm gonna go ahead. I put a link to the survey on the chat bot. If it doesn't pop up on your screen, you can go ahead and click on the link and answer the survey. We appreciate all the answers. And our next webinar is going to be September the 1st, aquatic weed management. Dr. Todd Sink will be the speaker. And I forgot to put that on the slide, but it's going to have one CEU IPM attached to it. So those are folks that are looking for CEUs. We'll have one IPM on our September 1st webinar. I see some other questions coming in. He says, great job.
Thank you very much.
Yes, thank you very, very, very much. I really enjoyed it. Great job, Tiffany.
Great. Like I say, if you guys have any questions or need any information, please feel free to contact me, and I'm happy to follow up by email or by phone.